rules pertaining to Chapter 13 cases. We've got Rachel Flinn, the attorney for Russell Brown, Kim Swafford, the new at Maney, Lisa Thompson, the attorney for Dianne Kerns. Just a little housekeeping here before we get started. If you would, please make sure your name, not your telephone number, is on your Zoom sign-in screen. This is for CLE purposes. This is an event open to the whole community, so we've got lots of attendees here. We're happy to have you all join this ACBC event. The CLE session is being recorded for future viewing, so we do ask that you please keep your microphones muted during the presentation. If you have any questions or comments that come up during the presentation, if you would type those into the Zoom chat box so we don't interrupt. I'll try to monitor that chat box, and I might chime in with any comments or questions throughout the presentation, but more than likely, we'll reserve those comments and questions for the end, where anyone is welcome to unmute and even show your face if you'd like to pop in with any questions or comments. And again, we'll preserve the items in the chat for the end of the session. We have somewhat extensive materials for today's session. All of them have been posted to the ACBC event page, the event page. The most pertinent have been placed here in the chat function on Zoom. We'll put them in the chat box again shortly for those of you who have just joined. Towards the end of today's session, we're going to post the CLE certificate in the Zoom chat for you to save. Please be sure to grab that certificate when it's posted. I will make a verbal announcement when it's in there in the chat so that you can grab it and save it. And hopefully you'll all get it saved before we close out this session. If you can't see the chats, the PDFs in the chat for any reason, if you would please type your email address into that chat or send us an email at admin@acbcforum.org and we'll email the documents over to you. I'm pleased to be able to moderate this discussion today. I'm Krystal Ahart. I am an attorney with Kahn and Ahart, PLLC. I've had the pleasure of working with Jim Kahn for nearly 25 years. I feel like I'm not old enough to say that. We do a lot of consumer cases in all chapters and also some small mom and pop businesses in Chapter 11. I'll turn it over to Rachel for intro.
Hi, good morning. My name is Rachel Flinn. I'm the staff attorney for Russell Brown. And I've been with Russell for, 11 years now as a staff attorney. Before that, I handled consumer bankruptcy cases for debtors. And I will turn it over to Kim.
Good afternoon. I'm Kim Swafford. I've met some of you. I do 341s quite often for Ed Maney. I've been with his office for all of 6 months. Prior to that, my past life, I was the AUST in the Eastern District of Tennessee, and also 3 years in the Middle District of Tennessee, and also 2 years in San Diego. So I'm old, but but chapter 13 is really wasn't something I delved way deep down into in my past life, but I'm enjoying it, and I hope I can be helpful to all of you. Lisa.
And my name is Lisa Thompson. I have been staff attorney for Dianne Kerns for just a little over a year right now. Prior to that, I have been doing consumer bankruptcy for about 25 years. So we can go to the next slide. So here are our disclaimers. Today, this is all new to us too. And we put together this presentation in like 2 weeks. And everybody just kind of came together to get it done. So we don't have a crystal ball. We don't have all the answers. These changes do affect everyone. So this is not just oh, debtors council need to pay attention to this, or, oh, this is only for the trustees. This affects creditors too. And I think that there's going to be a lot of time, or a lot of creditors that may not pay attention so much to this, and they're going to miss some deadlines because they're fairly tight. So we're going to learn as we go. We will keep updating you as we learn more information. And if there's anything that, comes out, ACBC will be keeping you posted. So stay tuned.
Thanks, Lisa. We wanted to start by letting you all know how we got here. I know these changes are pretty big. At least most of us that have been practicing here in Arizona have not had initial confirmation hearings set before. But this was a mandate from the Ninth Circuit. Last year, the Ninth Circuit issued a mandate for all bankruptcy courts in the Ninth Circuit to certify that their local rules were consistent with the federal rules and also with the code. And surprise, surprise, ours were not. And we'll talk a little bit more about that in a few slides. But as a result, Local Rules Committee was reformed to review the local rules and make recommendations to the court. And through that process, the Local Rules Committee made several recommendations to the judges, and ultimately the judges adopted General Order 26-4, which will help ensure that at least the team and the judges believe that it helps ensure that our Arizona local rules conform to the federal rules of bankruptcy procedure and also the bankruptcy code. This resulted in revisions to Local Rules 2084-9 through 2084-12, and also some technical corrections to 284-15. We'll review those rules with you today. And then lastly, the Local Plan Form 2084-4 was also revised. 1324 is the code section that we really were not following here. It provides that, except as provided in paragraph B and after notice, the court shall hold a hearing on confirmation of the plan. And this jurisdiction, I understand many years ago, we used to do that. But more recently, at least as long as I've been practicing here, we've just done it by SOC, right? Stipulated order confirming the plan. We've not had initial confirmation hearings. But this code section does require it. It says the court shall, there we go in all caps, the court shall hold a confirmation hearing. And that confirmation hearing, it says the code says may not be held earlier than 20 days and not later than 45 days after the date of the meeting of creditors under 341A, unless the court determines that it would be in the best interest of the parties to hold a hearing at an earlier date and there's no objection to such earlier date. So in the process with the participation of the clerks of the court or staff from the clerk's office, they are trying to ensure that we are right within that 20 to 45 day window. I understand that not all jurisdictions are quite there. These hearings are generally set at a specific time of month, so depending on when the case is filed, it might be just a little bit. I heard, I think it was Maria Mathis say, it might be like 47 days in some cases, but it should be very close to the within 20 to 45 days after the initial meeting of creditors.
So are you done, Krystal? Sorry.
Yep.
So as Krystal mentioned, the new local rules amend 2084-9 through 12 and 15. There were some technical revisions that had to be made to the plan just to maintain some consistency between the rules and the forms. And just briefly, I'll just give you like the view from 10,000 feet here. 20849 establishes deadlines for objections. 10 requires a trustee rec be filed before the ICH, which I will try to resist calling the itch. And 2084-11 sets the ICH no earlier than 20 days and no more than 45 days from the meeting of creditors. And then 12, it's amended to permit a confirmation after the ICH by submission of an SOC. And 15 requires a hearing on a motion to dismiss be scheduled on 21 days notice. So that's just sort of an overview, and everyone's gonna delve into that a little deeper as we go on. And then the effective date of this, as I'm sure you all know, was June 1st, 2026. And that was in that general order. And we learned recently that Judge Gann has the first confirmation hearing set on 8/20. So he is going to start us off. The notice has changed, the initial notice that goes out. So you might want to make your clients aware. It'll have the 341 information and how to get into the 341. And then it'll also have an initial hearing. So they'll have to note that because they may or may not have to come. I imagine they will be coming though, sometimes. It has the proof of claim dates and it has the government proof of claim dates, just like always. So we have provided in the packet, I think that will go out, a example of a notice that went out and it's been redacted, but anyway. So as a practice pointer, we just wanted to point out that you're going to have two separate Zoom logins. Your clients will. You'll need to point that out to them. And you need to tell them that the Zoom link for the 341 is not the same link for the confirmation hearing. And based on my experience, sometimes people have a hard time getting into those meetings. So you might want to emphasize that to them.
Thank you, Kim. And just for everyone's benefit, I did post a copy of the redacted 341 notice here in the Zoom chat. So you could take a look at it while we continue to go through.
Okay. So as I mentioned, 20849 establishes new deadlines for objections to confirmation, clarifies how those deadlines are calculated and when a case is dismissed and later reinstated, how the deadlines fall, and deletes the provision permitting the waiver of the confirmation hearing. So the deadline for objections went from 14 days before the 341 to 7 days before the initial confirmation hearing, or 28 days after service of the plan, whichever is later. If a case is dismissed and reinstated, the initial confirmation hearing may be rescheduled and the objection deadline moved to 7 days prior to the rescheduled date. And then subsection B of 20849 is used to provide, if no objections, the requirement to hold the confirmation hearing is waived. All right, and then 208-410, this requires the trustee's recommendation be filed before the initial I think it's 3 days before the initial confirmation hearing, unless an amended plan is filed. And then also revises the dismissal procedures, as I mentioned earlier, and incorporates some deadlines, some notice provisions for that. So A1 of 208-410, trustee rec no later than 3 days before the initial confirmation hearing. A2, amended plans, trustee's rec is due no later than 3 days prior to the initial confirmation hearing or 14 days after the creditor deadline is set, whichever is later. Because an amended plan, those deadlines might slip depending on when it's filed. And then on A3, modified plans, the trustee rec is due within 28 days after the modified plan. 28 days after the creditor objection.
Okay, moving on to 2084-11. This is where we note that each case now requires an initial confirmation hearing for cases filed on or after June 1st. The hearing, as Krystal pointed out earlier, needs to be no earlier than 20 days after the 341 and no later than 45 days after the 341 media creditors. And either a debtor or the debtor's attorney, the trustee, and also any creditor who's filed an objection, which remains unresolved, must attend that initial confirmation hearing.
Thank you, Rachel. Before I move to your next slide, I just wanted to hone in on the underlined or debtor's counsel. We've gotten a few questions about whether or not the debtor, his or herself, must appear at this initial confirmation hearing. That was not the intent of the local rules committee or the judges. If debtor is represented by any of you wonderful folks, your appearance will be sufficient. The debtor, him or herself, represented debtor, him or herself, does not need to be at that initial confirmation hearing, or ICH, as Kim calls it.
And then 2084-12, it allows the confirmation to happen following the initial hearing without another hearing, as long as we have a stipulated order confirming plan signed off by the trustee and all objecting creditors, and that order is lodged with the court. If you do already have a continued hearing status or confirmation hearing set, make sure to put in your stipulated order confirming plan that this order vacates that hearing. That will help speed up the process, and you don't have to file a separate motion or notice to vacate that confirmation hearing.
Thanks again, Rachel. And I don't know that we said it anywhere in here, but I think the intent by all the judges and the local rules committee is, I think everyone understands it's going to be very unlikely that a plan, even an original plan, can be confirmed at the time of the initial confirmation hearing, at least initially, as we're getting used to this program. So I think the plan is that unless there's an ability to confirm very quickly, I think the plan is to set a continued confirmation hearing at that initial confirmation hearing. So that's where Rachel's saying if you have a date set, which will have been set at the initial confirmation hearing date, you will want to vacate that continued hearing in the SOC if you can get everyone on board before that continued date. Kim?
Initial confirmation hearings. The website says that there are objections still pending after the hearing. The court will treat the initial confirmation hearing as a status conference. and we'll determine the appropriate procedure. So like we just mentioned, we could put it out 30 days, but in the meantime, everyone could come to an agreement possibly, and we could submit an SOC. Did I say that right?
Yep.
Okay. So there are new docket events and so there's an updated notice of Chapter 13 bankruptcy cases for case filed after 6/1. And we have all of that information on those new docket events included in your materials. And the good news, at least for us, and for those of you who do a lot of 341 meetings, they will not be on Wednesdays. We will not have any confirmation hearings on Wednesdays. So we won't be jumping around trying to get to confirmation hearings from 341s.
And I think we also want to specifically note that these hearings, at least as we are advised, and so far we're seeing in the notices, that all of these initial confirmation hearings will be set via Zoom. So we've heard some feedback that there's some concern about increased costs, which we always want to be sensitive to, and the court does as well. And I think that's one of the things that the court took into account in going ahead and setting these initial confirmation hearings via Zoom. So I believe that all the judges are on board with that procedure.
Sorry, I forgot to mention that, Krystal.
That's right.
And moving along to 2084-15, this rule has been amended to require that hearings on motions to dismiss be scheduled on at least 21 days notice, except as otherwise provided. So make sure if you have a debtor who receives a motion to dismiss, and let's say they don't care, they want the case dismissed because they can't convert to Chapter 7 due to a prior Chapter 7, they want the case dismissed so they can proceed with filing a new Chapter 7. You know this, you get the motion to dismiss, usually you'll email me and say, we don't care. Go ahead and lodge a dismissal order when the deadline expires. Instead of just emailing me, please go on. There will be that docket entry that was discussed, and that's under the plan tab, and it just allows you to say that the debtor does not object and they are waiving that hearing. I know that our office will be filing the motions to dismiss, and then after the deadline to object has expired is when we'll set the hearing, because most of the time those motions to dismiss are resolved within the 30 days. And no hearing is going to need to be necessary. So to keep the court calendar clear, I'm not going to notice out a hearing unless I really need to, but that'll be up to each trustee's office how they want to handle that, if they want to set hearings right away when a motion to dismiss is filed, or if they want to wait and give you some time to resolve the motion to dismiss.
Thanks, Rachel. And on this one, this is also a change to come into compliance. I believe it was with the code, and I tried to find the code section. I couldn't find it quickly. I don't know, Rachel, if you remember if it was a code section or a rule, but I believe it's the code. It says the court shall hold a hearing on dismissal of a case.
1324.
Thank you. That's what I thought it was, but I didn't see it. Thank you. And that's why the change in this one, as we know, the trustees historically would file a notice of intent to lodge a dismissal order. And if there wasn't action within the allotted time, they would simply lodge the dismissal order with the court, and the court would sign that order, dismiss the case. But the code does require that the dismissal hearing be held, or at least scheduled. The trustees recognize that sometimes debtors actually want the cases to be dismissed. They don't have an objection to the trustees' motion to dismiss, and that was the reason for creating the waiver that Rachel mentioned.
And I guess I kind of skipped ahead. So we have the new docket entries. We have the waiver of dismissal hearing and no objection to dismissal. That's one that debtors counsel will be filing. It's under the plan category. It's great because it's just a docket entry. You don't even have to attach anything to it. So we tried to make this easier for you to let us know and let the court know, so we're not setting hearings for you to show up and state on the record that your client has no objection. Also, there's one for the trustee that once you waive the hearing, let's say a hearing got set and your client finally calls you back at that point and says they have no objection. So you file the waiver of the hearing, then the trustee can go in and use an event docket entry that allows us to vacate a pending hearing and withdraw or move forward with the motion to dismiss. This could happen too if you resolve it, you've made all the plan payments, we can go in and just do request to vacate the pending hearing. So whether you're waiving one or simply the debtor got current on plan payments, resolve the motion to dismiss, it allows us to vacate hearings in a much simpler manner than filing a separate motion to vacate.
So we wanted to also take this opportunity to talk about the failure to file tax returns prior to the 341. You are going to be going to hearings with the judges. And when I was practicing, I considered a plan a success if I never saw the judge. Like that was the goal. And now you're going to be seeing the judge. So we wanted to talk about filing tax returns. Your debtors should file 4 years of the last 4 years of their tax returns prior to the meeting of the creditors. And 1308 says that they must be filed before the first 341 meeting. I cannot tell you the number of times in 341s where, one, the debtor doesn't know, and two, people are like, oh, well, we're going to get it done. There's actually like code that says that, they need to be filed before the meeting of the first meeting of the creditors. If they haven't been filed, you can ask for your next slide, please. I'm sorry, I kind of like mixed them up. So you're also supposed to provide the previous tax year's tax returns to the trustee 7 days before the date first set for the meeting of the creditors. So you want to also keep that in mind, but that's only 1 year. Versus 1308 says you need to have 4 years. But this is the section of the code that says you must provide 7 days before the date first set for your first meeting of the creditors, which is going to matter in a minute as well. Next slide, please. So the Chapter 13 trustee has the ability to discretionary hold open the meeting for a reasonable period of time, but 1308B says that that's only 120 days from the first date of the 341 meeting. After notice and hearing, judges may extend that period of time, that 120 days, for an additional 30 days, which is also in the code. And the order to extend that deadline from the judge must be entered before the deadline of the first 120 days. So if you get your Chapter 13 trustee to continue the meeting of the creditors so tax returns can be filed, that's awesome. If you need an additional 30 days, you're going to have to get that order from the judge prior to the expiration of your 120-day time period before the 341s. And the court shall only confirm a Chapter 13 plan if the requirements of 1308 have been met. And if the debtors fail to get the returns filed in accordance with the code that I just told you about, the case can, and in some courtrooms will, be dismissed. And it doesn't. I had a case where we were in court over a different matter, and it turned out that the debtors had not filed, I think it was 2022 tax returns, and the case was dismissed. And that was not the reason why we were there. So I think that everybody, we've preached about this for years, that you should, that we need to follow the code. Next slide. But I really, unless it is a true emergency, like someone's going to lose their house the next day, it is very dangerous to not have filed to file a case without your debtors having filed the last 4 years of state and federal tax returns. I'd also verify that they were actually filed. In the last couple years before I took this job, I had a couple situations where my clients swore that they were filed, and in fact paid for them to be filed with several companies. And then it came down to it, like they weren't filed for whatever reason. And so I don't know how you do that. And I most certainly am cognizant that it's a lot of work. And I would be watching this as debtors counsel going, but you really need to verify in some way, or at least cover yourself, when your clients are saying like, oh yeah, I filed them, if you haven't had eyes on them and know that they were in fact filed, just let them know that they could be looking at a situation where their case gets dismissed, even if they've done everything else right. You also want to, if you're in this situation where you do need to get a little more time, You need to remember to ask the Chapter 13 trustee to continue the 341 meeting, so that you do have that extra 120 days. Sometimes our office will just grant it, and other times you just need to ask because we may forget. Next slide. Thanks, Krystal. There's a case that came out of Washington just like 2 weeks ago, that if you convert a case from a Chapter 7 to a Chapter 13, the requirements of 1308A apply to the first date of the meeting of the creditors. So the first date in a case that's converted from 7 to 13 would have been in the Chapter 7 case. And that really hurt the debtors in the case that I'm referencing. If you want the citation to that, just shoot me an email and I will send that to you. But I think that, if you've got a situation where you're going to convert a case, you need to look and see, if you're converting from 7, which has different requirements, you want to look at that. And if you're going to need an extension, as I said before, you need to start the process early, to get your order entered before the 120 days expires. And truthfully, my practice pointer is I just didn't file cases unless the tax returns were filed, because my clients never did anything after we actually filed the case. They were like, phew. And, so continue on. I don't know who's next.
Rachel. Oh, I'm up. Now we're going to talk about changes to the model plan form. There are on the court's website, there are now 2 versions. Actually, there's probably 4 versions because I think they're both in Word and in fillable PDFs. It's going to be important that you select the right plan form. Note that these new rules are effective for cases filed on or after June 1st. So if you are preparing a modified or an amended plan for a case that was filed before June 1st, you need to be sure and continue to use the prior plan form. However, for all cases filed on or after June 1st of the new plan form, which we'll look at a little bit more today, needs to be used. The changes to the plan are only on pages 1 and 2, and they're mostly just dealing with the deadlines, just to make them correspond with the rules that have been updated. There's a note at the bottom, and I personally don't use the best case plan form. It's obnoxious, and I manually do my plan, so I have not had a chance to check myself because I just don't use it. But it is very important that you check with your bankruptcy software provider. If you are using your bankruptcy software to generate your plan, ensure that the software is helping you pick the right plan form based on the case filed date. They can't just pick the plan based on the preparation of the plan date. That's not going to work.
All right, and before I move on with my slides, I saw a question about the bankruptcy code and the motions to dismiss requiring hearings. That is under 1307C, where it requires notice and a hearing before dismissal. And then moving on, breaking down a little bit more about the new model Chapter 13 plan form. Again, you're going to have to look at when your case is filed, in order to determine if you need the new one or the old one. But the new one is going to have some new rules regarding dismissal of the case. It does spell out, currently we have not been noticing out motions to dismiss to creditors when they're filed by the Chapter 13 trustee. The court used to. The court still notices out the dismissal order after it's signed by the judge. That gets noticed out to everybody. But in Chapter 13, most creditors are happy when a case gets dismissed if a debtor is not making their plan payments. So the plan does warn all parties that they're not going to be receiving notice unless they're the debtor or the debtor's counsel of a motion to dismiss the case. And just if you're a creditor attorney and you want notice of these, then go ahead and file a notice of appearance and sign up on BNC to get the electronic notifications. And that way, you can set it up so every day at midnight, you're going to receive your notices and all of your cases, and you can go through and see if there are any motions to dismiss that you'd want to object to. Usually there's no reason to, but just in case you want to keep on top of that, sign up for ECF, electronic noticing. And then we have more on the model plan form. So basically, it was also updated to reflect the new objection time frame to add in that the objections are due 7 days prior to that initial confirmation hearing. So that's the main difference between the old form and the new form, which is why you can't use the old form in new cases and you can't use the new form in older cases because there's no confirmation hearing for debtors or for creditors to object by. The notice of initial confirmation hearing will be provided to all parties on the master mailing matrix. So this is going to go out through BNC at the same time. It's on the same notice as the 341. And we have objections to confirmation of a modified plan. Those are always going to be due 28 days after service of the modified plan. We're not going to be having confirmation hearings and on modified plans. So some more good news for you that you're not going to be dealing with confirmation hearings once a case is confirmed once.
Thoughts? Random thoughts? I get one. I want to hone back to Lisa's discussion about tax returns. It's just so critical, and I don't think all of us are as in tune with it. But I think the practice pointer is that we must be reviewing proofs of claim in advance of the 341 meeting. I'm sure all of us have seen the Department of Revenue claiming that certain tax returns from many moons ago have not been filed, and we need to be seeing those and helping the debtor get those returns filed, hopefully in advance of the 341 meeting. But as Lisa said, if they aren't, if we have a proof claim on the record that shows unfiled tax returns and we've not resolved that by the 341 date, it is critical, I think, that debtors counsel in a Chapter 13 case asks that the meeting of creditors is continued. Again, as Lisa outlined, as the code outlines for us, as some of our judges have definitely honed in on, a plan cannot be confirmed if the deadline is missed, right? So if the first meeting of creditors is concluded on that date, and for some reason those returns, in fact, not filed, and I know sometimes those proofs of claim are in error, and that may be one thing, but if there really were unfiled returns, you may be facing a situation where there's no real hope for ever confirming a plan in that particular case. So that's my random tidbit.
And it's only 4 years, right? I mean, it's the 4 years preceding. So, and I do know from some tax attorneys that, sometimes if they're like 10 years of tax returns, there are reasons not to file anything but the last 4. So, when you get into those situations, but definitely really be cognizant of the code. I feel like it hasn't been paid attention to, and attorneys are like, oh, yeah, it doesn't matter. No, it does. And I think that it's even going to be, now that the Ninth Circuit is telling us, thou shalt follow specifically the code, I think that it's going to be a bigger issue.
And on the questions here, I noticed that we just got one about ADOR already started filing like 2025 unfiled returns in January. On cases like that, when we were far enough away, we were basically just reminding attorneys at the 341, hey, this got to make sure that they get filed on time. Just make sure they're filed by April 15th. And if not, then you're going to have an issue. So I would say, it's not a big deal. We're not going to hold open every case if they haven't filed their 2025 returns in January. But just make sure your debtors are aware and they're ready and able to get their tax returns filed on time that year.
I do believe that I'm sorry. I do believe that there's some case law that says that, even that, like, it always made me nervous. And I think you should do some research when you're filing cases like in February or April or March. I think you want to make sure that you always have your hearings continued, because I think technically the way the bankruptcy code works is, as of January 1, that's when your taxes are due, even though the return is not. And so there's been some issues with that requires some more research. So I'm kind of talking off the top of my head, and I'm most certainly willing to give you some more information on that if you're interested. I did see that Andrew Nemeth asked a question about extensions. The extensions don't matter. It's when they needed to be filed. And they need to be filed before, like, it doesn't matter if you're on extension, they need to be filed before that 341 or within that 120 days. We don't, extensions don't matter.
Yeah, and
Right.
13.
Do you agree, Rachel?
Yeah, definitely extensions don't matter. And if you're at all concerned about it, definitely
Don't
ask
file
us.
the case.
Yep. Don't file the case, or, ask us to hold the case open, hold that meeting open, and we're happy to do that. We want to save cases as well. That will mean just because you hold the hearing open, you're not going to get a new confirmation hearing date. The initial confirmation hearing date is going to stay the same. So you're going to show up at that initial confirmation hearing, and we're going to let the judge know 341 has been held open because of unfiled returns. We're requesting, let's say, a 90-day continuance of the confirmation hearing to hopefully by that time we can get the case confirmed. So just so you're aware, that's holding cases open, continuing the 341 for whatever reason. That is not going to reset the confirmation hearing unless the case was dismissed prior to the 341 date. In that case, you may get a new confirmation hearing, but you'll have to check on that when the case gets reinstated and check the docket.
1308 is the section of the code that we're talking about here, and 1308 refers to all tax returns for all taxable periods ending during the 4-year period ending on the date of the petition. All right, so I think this early in the year discussion, the January through April's tax filing deadline is really a critical point, and a point that we should all be carefully aware of, because as Lisa mentioned, the tax returns technically should be filed as of January 1st. So even if you're before your client's before the April 15th deadline, I think there could be an issue there still. So
Yeah, and if your client's not required to file tax returns, most certainly that is fine. You just need to make sure that the trustee is aware of that and that you've done an affidavit indicating that they do not need to file tax returns. And I would be very proactive with the Arizona Department of Revenue with that. And if you prove to them that you did not have to file taxes in Arizona because you were a child or you didn't make enough income or you lived in Massachusetts, they will step away from what they're doing. I just think that you want to do it faster to make sure that this isn't an issue.
and the department does require, as Lisa referenced, an affidavit in that regard, but they are pretty quick. Generally, they are pretty quick to amend, and hopefully with these sensitive issues, they'll be more quick if we ask them to.
Yeah, but they actually want an affidavit, not like wet signature, notarized, not electronic.
Not a declaration, must be a notarized.
Not, yes.
All right, any other thoughts?
I just have a general thought or maybe some advice. This is a new procedure for you all. It's totally different than what you're used to. But I think ideally, if you look at it, like I said, from about 10,000 feet, because I never was down in the nuts and bolts of this before, it will make the cases move along, I think, a little faster because we're going to have some deadlines set. And it would be awesome if all objections could be resolved by the initial confirmation hearing. And then you could submit an SOC right after the bar date and things could move forward. And I know that SOC process is a back and forth and sometimes takes some time. So I don't think it's a bad thing that we've got some objection deadline, and we've got some deadlines set in here, definite deadlines for the creditors and for you all. And hopefully we can make this process work.
Quick comment, Krystal, about the wedding signature with the ADOR declaration regarding, no need. What I found is if I electronically get a DocuSign signature and then file it, they'll accept that electronic signature because of the declaration of electronic filing. But if you're just sending them the declaration directly, they won't accept it.
Interesting. What do you file with the court, Sean? Notice of filing affidavit?
No, I just file a declaration regarding non-filing of taxes, whatever it is. And then I will, I think I usually download the actual conform copy, then email it over to them. I've been able to get them to accept that.
That's a good practice pointer. Obviously, it puts it right on the record.
That's great.
Always send them to DOR by email, but that's a good way to have it be a bit more visible. Thanks for that, Sean. Any other thoughts?
In response to Bill's question about reinstatement, so we have been in cases, I know the panel has noted that there's some new Ninth Circuit case law, but We have been in the past reinstated cases for unfiled tax returns if the judge will allow it. Judge Gann will not allow it. So we won't even sign off on those motions to reinstate because we know that Judge Gann isn't going to sign the order. In other cases, I know our office has been generous to do that, but that may soon end with new case law. The judges may be less willing to accept those reinstatements. So just be sure to get everything filed before the 341 or have the 341 held open. That way you don't have any surprises. I had a case, wasn't a Judge Gann case. We knew the debtor had unfiled taxes. We waited a long time, held it open. He didn't get them filed. We finally concluded the 341 and we had a creditor object to confirmation because of unfiled taxes. And it wasn't a taxing authority. So especially in cases where you have, a creditor that showed up at the 341, they're aware of what's going on, they may also object. So definitely just get the taxes filed, then you have to deal with it.
And on that note, I haven't reviewed the recent case law to be candid with everyone, but 1325 is confirmation of plan. And it says the court shall confirm a plan. And then subsection 9 says, if the debtor has filed all applicable federal, state, and local tax returns as required by 1308, which was the statute we were looking at earlier. So the code sections tie together and tell the court that they should not be confirming a plan if the tax returns were not filed. And that's what Judge Gann, I believe the code is what Judge Gann is really honed in on. And
Yes.
Again, as Lisa mentioned, because the judges are getting, pushback, I don't know if that's the right word, but a little bit of pressure mandate from the Ninth Circuit to make sure that we're in line with the code. I think it's quite likely that some of the other judges are going to pick up on this and become more sensitive to the issue. So I think that we all need to do the same.
And again, it's the 4 years,
right?
Yes,
and
it's only the 4 years.
It's only the 4 years. There are reasons to not file, 10 years worth of tax returns if those are, but you got to do the 4 years. And it's kind of, if you don't get it within that 120-day, if you extend the period for your meeting of the creditors to conclusion, and even if you got another 30 days, if you don't get them filed, that's a fatal flaw, right? You're done in accordance with the code.
Yep.
So, you're gambling on your clients if they haven't filed them beforehand.
And you know whose fault it's going to be when the
and it's going to be your fault because you never told them, even though you said it 79 times and your face is blue.
All right. Any other thoughts before we move on? Hearing none, I'll move forward. Just to kind of reiterate and summarize the deadlines, the key deadlines that we've already reviewed, the initial confirmation hearing, or the ICH, not the itch, will be held in all cases. It's supposed to, again, be between 20 and 45 days after the initial 341 meeting, as long as that hasn't been moved to dismissal and reinstatement. The deadline for creditors to object to the plan is going to be 7 days prior to the date set for that initial confirmation hearing, or 28 days after service of the plan, whichever is later. And in our example, the case was filed June 2nd, the 341 is July 29th, and the confirmation hearing is September 3rd, if I remember that right. So the deadline in this case is actually, although the 14 days was shortened to 7 days, the creditor deadline for objecting is actually later, a little bit later in the case, because it's just 7 days prior to that confirmation hearing, which is quite a bit, set quite a bit out from the initial petition date. So just got to kind of monitor and play with the calendar a little bit and see how this all works out. If the case is dismissed after the 341 meeting, but before the original deadline for creditor objections, that deadline for objections will remain the same, or maybe it'll be 14 days after the reinstatement date, whichever is later. The Chapter 13 trustees required to file their recommendations no later than 3 days, and that is business days, at least during our discussion. I believe there's a federal rule that says if it's less than so many days, it's business. So there's a presumption there that it's no later than 3 business days prior to the initial confirmation hearing. So we're only going to have a short couple of days to review that recommendation in advance of our initial confirmation hearings. Within 30 days after the recommendation, the debtor must either comply by submitting a proposed SOC or file an objection. Right, I think there's some hope that maybe in some of the more simple cases, I'm going to try. I'm going to see if I can be the first one. We'll have an SOC submitted in advance of that initial confirmation hearing. I think that in many cases that is just not going to be feasible with the short time that we'll have the recommendations in our hands. But the trustees will have a shorter time to do those recommendations too. So maybe they'll be shorter and easier to comply with, and maybe we can get plans confirmed easier. We shall see how all of this shakes out. For amended plans filed prior to the initial confirmation hearing, the deadline for a recommendation or objection by the trustee will still be 3 days prior to the initial confirmation hearing, or 14 days after the last date set for creditor objections, whichever is later. And that's just going to depend on when the amended plan gets filed by the debtor. For modified plans, the Chapter 13's recommendation or objection is due 28 days after the last date set for creditors to file their objections.
So a creditor who disagrees with the valuation of collateral must file an objection to the Chapter 13 plan. So that's actually good news for debtors counsel if your creditor isn't filing an objection and you have crammed down some collateral. So creditors, if you're out there and you disagree, some creditors always do object. There are others that do not. So now it's very clear that you need to do that. If the debtor does not timely comply with the requirements that they are supposed to, the trustee may file and serve a notice of intent to dismiss with a copy of the proposed order of dismissal. In cases where the plan has been confirmed and no plan payments, or where no plan has been confirmed and no plan payments have been made, the notice of intent to dismiss is going to be held at the initial confirmation hearing. And we were talking about this a little bit earlier. And Rachel, could you reiterate what your thoughts are on that? It's that you're not going to file your recommendation, but you are going to send out a notice of hearing prior to the confirmation hearing, or are you just going to have the confirmation hearing?
Yeah, so this is kind of up in the air right now, and I thought that we had this in the rules, but I guess not. Notices of intent to dismiss, if there's no payments and no tax returns, our office, instead of filing a recommendation, it's going to file a notice of intent to lodge dismissal order stating that no payments have been received, no or unfiled taxes, whatever the case may be. Instead of filing a recommendation, if we may file that shortly after the 341 to allow 21 days before the hearing. And if we don't have enough time to get that filed before the confirmation hearing to give the 21-day notice of a hearing on dismissal, then at that initial confirmation hearing, we'll probably just continue it to 30 days or the shortest amount needed to get to that 21 days and hope, that the debtor makes a payment, or if they don't, then it'll be dismissed at the next hearing.
Thank you. Sorry to call you out on that.
No, that's fine. And it's honestly like something that we're still working on here because of the condensed time frame, but this is just another good reminder to make sure your clients are set up for TFS or whatever.
At the time of signing the paperwork.
Yep.
Right?
Get them set up right away. That way you're not going to have a case that is going to be held up because there's no planned payments made.
And there will be hearings set if it's a post confirmation plan modification, or if I think that we might have said that wrong on the slide. And I wrote the slide, so I'm calling my own self out. The trustees must set a hearing on notice of intent to dismiss post confirmation. So there will be
That's
hearings
correct.
set. Yeah. I think that I just put it in funky.
And to answer a question on the questions here from Morgan, the amended rules don't require the tax returns to be filed with the court. This is a rule that we've had since forever. It's in the Bankruptcy Code. It's 1308, which requires the 4 years of tax years that come due prior to the petition date. So right now that would be like 22 through 25, I believe, need to be filed. Any older years You can probably work with ADOR and just pay estimated if you can't get them filed, or work with IRS to pay estimated. But those 4 years prior to the petition date absolutely need to be filed by the 341 date.
And you don't have to file them with the court. You need to have
No.
filed the tax returns and be able to prove you did. So it's not necessary to file anything with the court. Just you want to be able to, if your judge at the confirmation hearing, says, hey, or your trustee at your 341 meeting says, have your tax returns been filed for the last 4 years, you want to be able to say, yes, they have. If the Department of Revenue has filed something that says you haven't filed tax returns ever, and you know that that's mythical, that's okay. You just need to prove that you have in fact filed and then resolve that proof of claim.
Yes. And I'm sorry, we forgot to go back to Warren. Krystal, I'm going to let Warren make his announcement, and then we'll take some more questions.
Sure.
Warren, are you there? Yep.
Sorry, I was just making sure where these things are. Too many monitors. So those of you who don't know me, I'm a pretty self-important Chapter 11 attorney, and I am succeeding Rachel Flinn as the president of the Arizona Bankruptcy Inn of Court. That shows you how excited I am about it. And so what I wanted to do is tell everyone that I would like to have more Chapter 13 and Chapter 7 practitioners. Now, I know I've went through the names here, and I've seen some people have been, part of our group before. Some haven't. And we also recognize that the price can be a little steep. It's like, what was it? Like, it was almost $600 this past year. And so we're actually working on getting scholarships for Chapter 13 and Chapter 7 attorneys who want to do that, or essentially assistance sponsorships. We're just trying to get the big firms essentially to take up some of the cost of that. But my pitch is, we really would like to have you as part of our process. That doesn't mean you have to stop doing this thing. Obviously, this is fantastic and very lively. But it really is a good way to network. It's also a good way to get 8 hours of CLE a year and 8 meals, although I'm not sure what the meals are going to be like. We're going to be at the yard, and so I can definitely vouch for the drinking more than the meals, but it's still a pretty good place. And it's a good group of people. And so if you are at all inclined and then you want to talk more, you please feel free to call me, reach out to me. I think the applications are due June 30th. So if anyone needs an application, I will definitely give an application, a template to Krystal, but we have them, and you can just ask me as well. And we would be delighted to see you. So.
Thanks, Warren. I also have those applications if you need one, unless you have my email, so reach out to me as well.
I'll just put it in the chat. If you're interested, you can download the Inn of Court application from the Zoom chat here. It does say at the bottom that May 31st is the deadline, but the birdies
we're making it June 30th. Yeah, we were trying to get them in early, but usually it's June 30th. So you still have time if you would like to join us.
It is a great group, and I've been very busy with ACBC over the last several years, so I've bowed out of the inn for a while, but I do show up as a guest every once in a while. The CLE is always fantastic, the camaraderie and the networking is also always fantastic. So thanks, Warren, for chiming in. It is Q&A time, guys, so we do have a number of comments in the chat. I think most of them were just helpful comments to others, which is great. Thanks for sharing all of that. A lot of it hones again in on section 13.8, which is titled Filing of Pre-Petition Tax Returns. So I would strongly recommend a re-review of section 1308 about the tax returns. Again, I think Jim had either a comment or question about the last 4 years, and it does say for taxable periods ending during the 4-year period ending on the petition date. So I think if I'm interpreting correctly, if the case was filed, let's say December 15th of 2025, 2025 tax return is not part of this project, right? Because that tax year did not conclude before the petition date. In my scenario, petition date December 15th, prior to the end of the tax year. So you'd have your client would have a little bit more time to do their 2025 tax return in that scenario where the case was filed before the end of that tax year. There's some comments about payments, and as Lisa said in the chat, it's really not about paying the taxes. It is about filing the tax returns, and the code says if the returns aren't timely filed, the plan cannot be confirmed. And so I think we need to be sensitive to that. Anything else in the questions, comments? Again, there's some helpful comments that DOR accepts e-notarizations. That's another helpful tidbit. I do like the idea of filing them, though. I think we've touched on most other items in the chat, so unless there's anything else you'd like to speak up with now, I will first say thank you, ladies, for pulling this together in short order, and thank you for the disclaimers at slide number 1 that we're all learning this, and we're all going to have our learning curves. I will say these 3 ladies are wonderful resources to us. I have tapped into all 3 of them in various cases, and they are always there and willing and able to help work through special issues or even dumb question issues, if I may say so, because sometimes I have some of those. So, tap into them. They're here. They're offering their time to help you get your cases confirmed. That's the goal for everyone, including our clients. So use them appropriately. All right, guys. Well, thank you, thank you, thank you. I don't see anything else other than some thank yous and some hand claps. So thanks, everyone.
Thank you so much.
Thank you. Bye-bye.
Crystal, you might want to pop up the disclaimer.
Oh, yes. Thank you, Lisa.
And we have posted the CLE certificate and the PowerPoint presentation.
Thank
So
you,
save
Dianne.
that materials.
We'll keep the session open a few extra minutes so y'all can make sure and grab those. I closed the session out a little too soon last month, Dianne. You weren't here to monitor me, and then I had to just follow up by email with the certificate. A few people that closed out too soon, but the certificate is in the CLE chat, or the Zoom chat rather, and I'll put another copy there, so it's at the bottom.
Shall I turn the recording off?
Yes, please.
Thank you.